Ma'am, I'm going to stop you. We don't go into the merits on a compulsory issue. The request is denied. Do you have any other arguments or evidence you'd like to offer to the board?
I need to request for a brief recess.
She has not reappeared on Zoom, and at this time, we are going to move forward with the proceeding. We've heard evidence and argument, and Ms. Anderson had the opportunity to reappear and has not.
This is Thelma Andreson. She's a former Dallas assistant prosecutor. After the DA fired her, she whipped up some phony tax documents for her side business and applied for COVID relief. She received $20,000, and shortly thereafter, the loan was forgiven. The fraud wasn't. In November 2024, Anderson pleaded guilty in federal court to 1 count of wire fraud, receiving probation. She kept her freedom, but will she keep her law license? Today's hearing seeks to change that. She uses sovereign-style jurisdiction attacks, and then when those don't work, she vanishes from the Zoom call, never to return. Good plan. The board's ruling is yet to come, but her bar card is toast. It's not a question of if, but for how long. Let's roll nurse.
Is the respondent ready?
No, the respondent is not ready pursuant to the memorandum that I sent over to the board yesterday regarding potential perjury from opposing counsel in affidavits that were submitted after multiple requests that were made. And I have documented proof that the documents are fraudulent. And so with that, I am not ready to proceed because this needs to be properly investigated and vetted.
Ma'am, you raised jurisdictional issues, and under the rules, we have to take those up first. So we'll be proceeding on the jurisdictional issues first.
The jurisdictional issue is not proper, as counsel stated. He stated it was proper. It's not proper. And I will go back to the original notice that I received via email on September the 4th of 2025, where I sent counsel an email asking for proof of service. That was the first time I asked for proof of service. September 6th of 2025, I asked for proof of service and the original petition. September 8th, 2025, I asked for proof of service and the original petition. September 19th, I asked for proof of service and the original petition. September 25th, December 4th, December 5th, December 11th, December 12th, December 15th, December 16th, January 31st, and January 31st of 2026 and February 6th of 2026. The reason I asked counsel for proof of service and the original petition was because I was afforded that right to have the original petition and proof of service so that proper service would render personal jurisdiction, and it will attach. Every email that I sent counsel, he intentionally disregarded my request to have that information provided to me. And I stated to counsel in every email, and it's in documents that I have filed, and the emails that are a part of the exhibits, just give me proof of service. If you do not have proof of service or the original petition, you need to start this process over so that I can properly be served. The legal objection is the documents are not valid, which option and completeness, because the documents are not from the date and time. They are from after 2026. So I need it's not option and completeness because these documents, the metadata shows that it's from February the 10th that they were created, not August 28th, what it purports to be.
That objection is overruled. If you have no other objections, I will go ahead and admit those 7, 8, and 9.
Oh, well, my next objection is hearsay.
And Commission, are those business records affidavits in conformity with the rules?
Yes, ma'am.
The constable is not in conformity of the rules because it's missing the notarized signature.
Any other objections?
No.
Okay. 7, 8, and 9 are admitted.
And did you sign the green card?
Yes.
So you acknowledge receipt of the second amended petition on or about September the 29th.
I acknowledged receipt of the second amended petition. I do not acknowledge receipt of the original and the amended.
And that request for leave is denied. The court has already, or the board has already heard testimony that you signed the green card for the second amended petition. And we're going to go ahead and deny your motion to abate and move forward. This proceeding will be on the third amended petition filed on December 4th, 2025. And the board is taking judicial notice of the service documents on file and the green card that was attached to petitioner's Exhibit 7 already admitted into evidence today.
On or about May 21st, 2024, Ms. Anderson was charged with an indictment in United States versus Thelma Michelle Anderson, cause number 324-CR-00191-K in the United States District Court for the Northern District of Texas, Dallas Division, for allegedly engaging in unlawful activities regarding the Paycheck Protection Program, or the PPP. The PPP was a program that was implemented by the Small Business Administration during the COVID crisis to provide small businesses with forgivable loans, to pay for payroll and certain other expenses. Under the PPP, participating third-party lenders approved loan applications and dispersed the PPP loans to qualifying businesses. Respondent was indicted for intentionally engaging in wire fraud, 18 USC Section 1343, and for twice engaging in monetary transactions and property derived from unlawful activities under 18 USC Section 1957. On or about June the 27th, 2024, the respondent voluntarily pled guilty to one count in the indictment, and that is wire fraud, 18 USC Section 1343. Paragraph 12 of the plea agreement shows that this was done voluntarily and freely by Ms. Anderson. On July the 1st, 2024, Ms. Anderson signed a factual resume acknowledging that the government proved beyond a reasonable doubt the 4 elements of wire fraud. Element number 4 in the factual resume is that she intended to act with the specific intent to defraud. She voluntarily signed that factual resume. On March the 5th, 2025, she was sentenced, there was a judgment issued. She was sentenced to 4 years probation and also ordered to pay restitution of just over $20,000. At this stage of the proceeding, what the commission is asking for is an interlocutory order of suspension pending resolution of Ms. Anderson's appeal. There is no dispute that Ms. Anderson has been convicted of an intentional crime, a serious crime of moral turpitude. There's no dispute of that. She admitted voluntarily that she intended to defraud, and she was convicted of that. There's also no dispute that she has appealed this case, and it is pending before the Fifth Circuit Court of Appeals. At this time, we're asking that under Rule 8.04, that the commission order an interlocutory order suspension.
What we are essentially here for today, the admission of guilt, which is currently under appeal. The existence of this case has been heavily documented under a current investigation for fraudulent documents that were presented to the grand jury that expedited a unlawful indictment.
Ma'am, I'm going to stop you. Ma'am, I'm going to stop you. We don't go into the merits on a compulsory issue. What we have to argue is under Rule 8.04. The petition and the board is aware that is under appeal. That is on the record. So is there any arguments you have for the compulsory issue of why the board should not temporarily suspend you while the appeal runs?
I need to request for a brief recess so that I can gather information that my computer needs to restart. It is stuck.
The board will take a 5-minute recess. When we went off the record, Ms. Anderson had asked for a brief recess to restart her computer. We instructed her to be back on Zoom at 10:07 a.m. At approximately 10:17, the board received an e-file notification that Ms. Anderson had filed a document with Dallas County or another entity of the state and has not reappeared on the Zoom. Further, one of the representatives of the board sent an email copying the commission and Ms. Anderson with the ability to reappear on Zoom via telephone and instructing her to be back on by 10:20. She has not reappeared on Zoom. And at this time, we are going to move forward with the proceeding. At this time, we've got exhibits 1 through 10 admitted. We've heard evidence and argument, and Ms. Anderson had the opportunity to reappear and has not after her requested recess. So at this time, we are going to conclude the hearing and the board will take this matter under advisement. This concludes today's proceedings before the Board of Disciplinary Appeals. We are adjourned.
Thank you.